Hello, and welcome to the Self-Help Center's virtual workshop. This presentation is intended to prepare you for completion of a request for order addressing custody and visitation. In doing so, you will get a brief overview of the court process and learn some legal terminology to help you when completing your documents. Lastly, you will be introduced to a web-based document and assembly program that through a guided interview will help you to complete your documents. Before we get started, there are a few disclosures we're required to make to our court customers. They are that the Self-Help Center is a department of the Superior Court. Our services are limited to providing legal information and not legal advice. We can often and do help both parties in a case, and anything discussed with staff is not confidential or privileged. While we do have attorneys on staff, they do not act as anyone's attorney in any case. By continuing on with this presentation, you are indicating that you understand and acknowledge these disclosures as they relate to our services here at the Self-Help Center. Now let's get started. First, I'd like to give you a better understanding of the request for order, or RFO. It is paperwork for parties to ask the court to establish or modify an existing order. There does need to be either an existing underlying case or one that is being filed simultaneously with this request for order. Some examples of this would be a divorce or legal separation or an action for paternity. Know that either party can file an RFO and it can be filed anytime during the pendency of the underlying proceeding. The RFO can be used to ask for multiple orders other than custody and visitation. So for example, support or property control on a proceeding. But this particular presentation is specific to custody and visitation. Lastly, know that this will be your vehicle for modifying any orders in the future, even after a judgment has been entered. So essentially, this will be the paperwork you use to make any changes absent an agreement of the parties until your kids are 18 or 19 and graduated from high school. Now to the specifics of custody and visitation. Under California law, neither parent is preferred over the other. If you and the other parent have an agreement, you can ask a judge to make your agreement a court order. In fact, you can reduce your agreement to a written format and submit it to the judge for approval and never have to see the inside of a courtroom. But in the absence of an agreement, both parties will be required to meet with a child custody recommending counselor on the day of their hearing. But in the end, it is the judge who makes the final decision on custody and visitation. Child custody recommending counselor is a licensed marriage family therapist or licensed social worker who is employed by the court. Once the counselor is assigned to your case, they will continue to handle your case for any future hearing. Their job is to speak with you and the other party to assess the situation and then ultimately help the two of you come up with a plan that you can both live with. If they are unable to get the two of you to reach an agreement, then they'll make a recommendation to the judge based on what they determine to be the best interest of your child or children. Due to COVID-19, these hearings transitioned into telephonic hearings and are likely to remain as such for some time in the future. Now, I mentioned best interest factors earlier, so I think it's important to know what some of them are. So for example, it could be the health or the age of the children. It could be emotional ties between the parents and your children. It could be ties to school, home, and their community, or the ability of each parent to care for the child or children. Any history of family violence, and any regular or ongoing substance abuse by either parent. And of course, any factors the judge may find relevant to the case. Now let's talk about temporary emergency orders for a minute. There are certain situations in which emergency orders are warranted, and you're always free to ask for them. If granted, these orders go into effect until the time of a hearing. Examples of situations that might warrant emergency orders are situations involving alcohol or substance abuse, child endangerment, or maybe threat of child abduction. These requests require notice be given to the other party before the request is filed. The notice can be by phone, by email, by text, or even verbally given. Some exceptions can apply to this pre-notification requirement, but it will be up to you to tell the court why it should apply in your particular case. Just know that to make these special requests, there will be additional forms required at the time of filing your request for order. Now let's learn some legal terminology. Legal custody is the right to make day-to-day legal decisions on behalf of your children related to health, education, and their welfare. Examples of these kinds of decisions might be school or daycare the children will attend, what kinds of extracurricular activities they'll participate in, or deciding which doctor or dentist will treat them. Most parties agree to joint legal custody, but there are several reasons they might give rise to a sole legal custody order, such as domestic violence, maybe one parent acted or assumed the sole responsibility of the marriage during the marriage, or maybe the relationship is highly acrimonious, making it impossible to reach agreements. Now let's talk about physical custody. Physical custody is the right to have the children in your physical care, custody, and control. It refers to the amount of time the children are in each parent's care, custody, and control. Again, the preferred is joint, but it does not, however, equate to what many tend to refer to as a 50-50 custody arrangement. It means that both parents share in the bundle of rights to manage their children. Now, visitation spells out how each parent will have access or time with their children. There are many varieties of visitation schedules, but the best schedule is going to be the one that most resembles what you, the parents, did during the relationship and creates the least amount of conflict between you and the other party. In your description of what you would like the court to order, you can summarize your idea of a plan and work out the details with the counselor, or you can be very specific. In the end, the counselor's job is to help draw up the details, including days, times, and holidays. Okay, let's get started. There is a link below this video that will take you directly to the online portal where you'll be prompted to create an account. It is strongly recommended that you create an account online so you can save your work, use your account for any future purposes, email us your forms for review before filing, and print your completed documents before filing with the clerk's office. When creating your account, be sure to make note of your username and password. Your password must consist of at least 8 characters, 1 uppercase letter, 1 number, and 1 special character. Once you've created your account, the interview will begin. As you can see from this screenshot, there are various icons and buttons to help you navigate through the program. Once you've completed your forms or decided to take a break, you'll be presented with various icons to work with. They include a download icon so you can review your forms, save them to your desktop if you'd like, or print them out for filing with the clerk's office. There's also an edit or save icon to manage your answers, and of course an email option. Okay, you're all set to get started. When you're done completing your forms, we encourage you to email them to the Self-Help Center for a review before filing them with the clerk's office. Thank you for watching this presentation, and know that we are here to help you.